All right, good afternoon, everyone. We're beginning our afternoon docket. Who do we have in the jail? I think we just lost. Mr. Adams, who do you have?
This is Jake Wilson, Your Honor.
All right, and is it my understanding we're going to be able to plea with Mr. Wilson today?
That's correct, Your Honor.
And I don't have the plea papers with me. Has he already completed the plea papers, and do you have those with you?
That's correct. That's correct, Your Honor. We did that today.
Okay, and can you go over the terms of the plea for me?
Certainly. 10 years probated for 10 years, Your Honor. A $3,000 fine. Court costs of $290. Reimbursement of $835.
And this is on the third degree felony offense of evading arrest or detention with a vehicle?
That's correct, Your Honor.
Okay. Notice that our feed is a little bit slow out at the jail. Can you see and hear me okay, Mr. Adams?
So far, so good.
So far, so good. Bring in another here. All right, Mr. Wilson, I'm going to have you raise your right hand. Place you under oath. Mr. Wilson, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you may put your hand down. All right, Mr. Adams, before we go any further, I do want to let you know that I do not have my court reporter here with me in the courtroom. She's unable to travel to the courthouse today, so she's not appearing remotely either. However, I'm recording the proceeding today, and I wanted to inquire as to whether or not you want to officially waive a record for today's plea. My court reporter, Ms. Grisham, has indicated to me that she can take this recording and she can create the transcript of this she'll have a disclaimer in the beginning, but she can and will do that if a transcript is necessary. However, I wanted to see if Mr. Wilson is willing to waive a record today via transcription record.
Yes, Your Honor. Formally, we'll make an oral motion to waive the taking of a written record today.
Okay. All right. Court will grant that and we'll move forward. Mr. Wilson, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes.
Have you ever been diagnosed with any type of mental condition?
No. Yeah, I have. Yeah.
You have? What have you been diagnosed with?
Depression.
Depression? Okay, and make sure you speak up a little bit louder for me. Mr. Wilson, are you currently under any type of treatment or medication for depression?
Yes, sir.
Okay, and what are you on?
Just Celexa, antidepressant, and
Okay.
Seroquel.
Celexa and Seroquel? Okay, and do you feel like those medications are helping you with disorder and enabling you to have rational perception and understanding of today's proceedings?
Yes, I'm good.
Okay. And your attorney in this case is Mr. Mitch Adams. Are you pleased with his representation of you?
Yes, sir.
Do you feel like you've had enough time to discuss your case with him and have all of your legal questions answered?
Yes, sir.
And Mr. Wilson, where your signature appears throughout the paperwork, are you swearing to me that that is your true and correct signature and you've only signed the documents once you have read them and had them explained to you and that you've understood them?
Yes, sir.
All right. Mr. Adams, do you believe Mr. Wilson to be competent today?
I believe he is competent, Your Honor.
And you have explained to him his legal and constitutional rights?
That is correct, Your Honor.
All right, Mr. Wilson, you are charged with the third-degree felony offense of evading arrest or detention with a vehicle. That third-degree felony offense carries a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice and a fine not to exceed $10,000. Do you understand that range of punishment?
Yes, sir.
All right, Mr. Wilson, it's my understanding, as Mr. Adams has read your plea agreement to me, that you're going to be pleading guilty to that charge in exchange for the state's recommendation that your sentence be set at that maximum 10 years in prison. But the state's asking the court to suspend that sentence and place you on probation, community supervision for a period of 10 years, along with a fine and court and reimbursement fees. Is that your understanding? And that's what you want the court to approve today?
Yes, sir.
All right, Mr. Wilson, then to that charge of evading arrest or detention with a vehicle, how do you plead? Guilty or not guilty?
I'm guilty.
And Mr. Wilson, are you pleading guilty because in fact you are guilty of that offense and for no other reason?
Yes.
And Mr. Wilson, has anyone threatened you, forced you, or pressured you to plead guilty to that offense?
No.
Okay, court will accept Mr. Wilson's plea of guilt at this time. Mr. Adams, is there any objection to states 1, the stipulation of evidence?
No objection, Your Honor.
All right, states 1 is admitted into evidence and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
No, Your Honor.
From the defense?
Just that, Your Honor, we understand that there has been Mr. Wilson was arrested for failure to appear. It's our understanding, and if I could get some confirmation from Mr. Woodwick about this, that the state does not intend to proceed with any charge against Mr. Wilson for failure to appear.
Mr. Woodwick?
I'm not showing that the DA's office has been referred a case for a failure to appear. If there is one, the state will take that into consideration in the formation of this plea and will either reject, or if it's brought to our attention that it is still in existence, it's just not showing up in my system, we will dismiss it at the time it's brought to our attention.
Mr. Adams, do you know if Mr. Wilson's been indicted on, is it a bail jumping case?
That's correct, Your Honor.
Do you know if he's been indicted?
And he has not been indicted. I
Okay.
do not believe he has been.
Okay. So as the court understands it, then Mr. Woodwick, the state is willing to resolve that case today by rejection.
That's correct, Judge. We do not show that we have a bail jumping that is currently been referred to our office, and we have not created one. And at this time, we do not intend on, if we do receive one, we will reject it, and we are not intending to create one at this time.
Okay, very well. All right, Mr. Woodwick, can you go ahead and give me the facts to support the plea?
Yes, Judge. On or about the morning of June 19th, 3 o'clock in the morning, CPD was attempting to pull over a vehicle for defective taillights. The vehicle, what the police call slow rolled into the Ochoa's parking lot and then accelerated at a high rate of speed away, basically made it down 19, went to basically Ben Wheeler at the end of the, then went north towards Van. At the end, the defendant basically pulled through a field, abandoned his vehicle, and proceeded to run on foot, at which point he was then caught by, it appears to be CPD, and he was taken into custody at that time.
All right, Mr. Adams, any objection to that summation?
No objection, Your Honor.
All right, Mr. Wilson, if I approve this plea agreement and I place you on probation today, are you going to thumb your nose at my authority and run from this court and run from your responsibilities like you did that night with the police department?
No, sir.
You see where running got you before, don't you?
Yes, sir.
If you run again, figuratively or literally, if you evade law enforcement again, or you evade this court by not reporting to your probation department, what do you think is going to happen to you?
All right, go to prison
For how long?
and probably 10 years.
Do you say probably?
Yes, sir.
It's more than likely.
Yes, sir.
Probably is more than likely. Okay, you understand?
Yes, sir.
All right, the court then, based on the evidence, will find that there's enough evidence to substantiate the guilt. The court will convict Mr. Wilson of evading arrest or detention with a vehicle, assesses his punishment at 10 years confinement in the Texas Department of Criminal Justice. Institutional division, the court will suspend that sentence and place Mr. Wilson on 10 years community supervision. Court will assess a $3,000 fine, $290 court costs, and $835 reimbursement fee to Van Zandt County. Mr. Wilson, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department. And I need you to report to the Van Zandt County Probation Department no later than Monday at 10 a.m. Okay, no later than
Yes,
Monday
sir.
at 10 a.m. When you get out, you need to make sure that you're at that probation department no later than 10 a.m. on Monday. If there's a weather closure or something like that, then you won't have to have any concern, and then we'll just make it 10 a.m. the next day. You understand?
Yes, sir. Yes, sir.
All right, I'm gonna have you go with the bailiff and be fingerprinted if you haven't already. Other than that, we'll see you on probation, and let's hope for your sake that you and I don't see each other again.
Yes, sir.
Judge, I'd point out that this coming Monday may be it is President's Day. I don't know if adult probation will be open or not.
It is President's Day. The probation director told me to instruct them Monday no later than 10. So if we'll make that Tuesday no later than 10, because I'm anticipating that they will be closed. So I'm glad you pointed that out, Mr. Adams. So we'll say Tuesday no later than 10, weather permitting.
Thank you, Your Honor.
All right, we'll have you go with the bailiff.
Judge, I had another case on the docket, Miss Savannah Toon, but she was going to plead to probation this afternoon. She's not in the county jail and was driving over to Canton for this afternoon's hearing from Navarro County. Considering that the courthouse has been closed due to weather conditions, I advised Ms. Toon that it would probably be best for her to stop, turn around and go home to Navarro County rather than risk the weather conditions getting over here. I'm told by the court's coordinator that that a lot of items on the docket that are being reset until next week. And so I hope I didn't overstep my bounds by doing that. I wanted to let the court know what I respect to Savannah Toon's case.
And is there additional information regarding Ms. Toon, any personal circumstances?
Well, what I can tell you is that she's going to plead to probation. I understand that, according to her, that her house burned down last night. She's lost all of her belongings, but nevertheless, she was driving over here as of 11:45 today, and then when I found out that the courthouse was closed, I contacted her and advised her that I thought it would be safe for her to go home and that we could take care of her legal business next week or at the court's leisure.
Are you available on the 18th?
I think I am. Let me double check real quick. I am, Judge. In fact, I'm going to be over here for a couple of other matters anyway.
Okay. Will you be here in the morning or the afternoon or both?
I'm on the afternoon docket for next Thursday. I don't think I'm on the morning docket, but I can be if need be.
Okay, just one moment. All right, Mr. Adams, how about, I got a proposal for you. How about we set her for 11 a.m.? Since you're not over here in the morning, we can get you closer to the time that you would be here at 1:30. Just have her appear at the courthouse here at 11 a.m. And she can do her plea by video conference in my video conference room outside the courtroom. Or if you get all the paperwork done, she could appear elsewhere and have it all turned in before that. But how about February 18th, next Thursday at 11?
That works very well, Your Honor. Thank you.
All right. Does that? Oh, yes, you have Miss Ozuna at 3 p.m. And I believe that Henderson County is going to zoom in for us at 3 p.m. So don't know if you have time to get back to your office or if you want to hang out there at the jail or if you want to do it on your phone.
I think I have to get back to Tyler, which would be my preference. 64 is pretty clear coming over here.
Okay. So, so they'll zoom in with us at 3 o'clock.
Okay, very good. Thank you, Your Honor.
All right. Thank you, Mr. Adams.
Is the courthouse closed tomorrow too?
I have no idea. It's gonna depend on weather.
Yeah.
This morning it started out not closed, and then progressed to close at 10 o'clock, and then progressed to close, and progressed to close with exception.
That's what Patty wanted out with home.
Will you be careful?
Oh, yeah. Thanks, I'll see you later.
It starts good seeing you.
Remember when I said early combination?
Yeah.
So, together.
All right.
Okay.
Appreciate it.
I'll next question.
Deputy McLeish,
Yes, Your Honor.
am I sluggish on your end?
No, sir.
You are. It's real delayed. The audio's delayed. The movement's delayed. What I want to do is I'm going to ask, can you shut that computer down and restart it and then rejoin? Because I really like to be able to see the defendants, as in real time. So can you do that for me?
Thought it was something about the coffee I had this morning. Yes, sir, I can do that.
All right, thanks. Sorry, Miss Beasley. I want to try to, just having a difficult time seeing and hearing. There's a big lag. And so I want to, if we can improve it, we will. If not, we'll make it through. So I'm just gonna give her just a second to reset and get back in. And then we'll get going on yours next. You have, you had Donald Ellis.
Correct, Judge. And Montana Tippett.
And Octavius Thompson, Montana. So you're going to be pleading those two, and then Donald Ellis. This would be your first setting on that since I've removed Miss Thompson. Have you had a chance to meet with Mr. Ellis yet?
Have, Your Honor.
Okay.
And I've received some of the discovery, so we're already working on it.
Okay. See, Ms. Heisel's hanging out. Let's go ahead and
Judge, she put this morning's Zoom ID instead of this afternoon, so she's just been that the room is still open. It just says like it's loading. I did that the other day is where Ms. Heisel has been.
User error, Judge.
As Mr. Ashmore says, hanging out in cyberspace.
Thought he said the Phantom Zone
I'm
because
on-
he's
I'm
a
on the-
nerd.
I'm with the judge.
Yeah, Mr. Ashmore, you need to tell him that I'm not a nerd, so I don't track the Superman comics and all that like Mr. Ashmore.
Total nerd. I'll admit it.
I only got in on the tail end of this conversation. I'm not going to say anything.
Well, we were talking about you, so it's probably a good thing that we
Fair
stopped
enough.
what we did.
Well, I walked right into that.
Speaking of nerds,
All right, Deputy McCush, who else do we have available there in the courtroom?
We have Mr. Austin Dole for Casey Ashmore, and we have all three of Miss Beasley's clients in the room.
All right, let's go ahead and bring Miss Beasley. Go ahead, let's
All right.
with Mr. Ellis, Mr. Donald Ellis.
Mr. Ellis, come on up. Sorry about that.
All right, Ms. Beasley, this is cause number CR 19305, State versus Donald Brian Ellis. The court had set this on Ms. Ann Thompson's motion to withdraw as counsel. The court granted that motion without a hearing. I think we've probably had no less than 3 hearings before on Mr. Ellis's desire to have Ms. Thompson removed as counsel. The court had also previously appointed Mr. Richard Schmidt as secondary counsel to Ms. Thompson. At her request. With the removal of Ms. Thompson, the court has also removed Mr. Schmidt. So Ms. Beasley, you are the new court-appointed counsel for Mr. Ellis. And what I'm going to do is set this for a pretrial hearing, not for Mr. Ellis, but for you, Ms. Beasley, so that if there's any pretrial motions that you think you need to file to protect yourself or your client, then I want to give you the ability to do that. So I want to know, are you available on either March 23rd or March 25th?
I'll check, Judge. March 23rd, Your Honor, I already have to be at the jail.
Okay, then let's set Mr. Ellis for pretrial on March 23rd. And state, if you will help Ms. Beasley ensure that she's received all the discovery that you have available. Ms. Beasley, I would ask that you reach out to Mr. Schmidt and Ms. Thompson to see if they have any discovery they can provide you so that there's not duplication by the state trying to provide the discovery.
Yes, Your Honor.
yes, Judge, we will work with Ms. Beasley and make sure she has everything.
Thank you, Mr. Woodwhite. All right, Mr. Ellis, we'll see you back on March 23rd. All right, either Mr. Thompson or Ms. Tippett, either one, whoever you want, Ms. Beasley.
Mr. Thompson is standing at the podium, if that's okay.
All right.
That's fine.
All right, Mr. Thompson, I need you to raise your right hand. I'm going to place you under oath. Mr. Thompson, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
Okay, you
Yes.
take it down. All right, Mr. Thompson, are you Octavius Thompson?
Yes, sir.
And Mr. Thompson, what's your middle name?
I don't have a middle name.
So the NMN means no middle name, I suppose?
Yes, Judge, that's the way our system recognizes it.
Okay. Mr. Thompson, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Ms. Debbie Beasley. Are you pleased with her representation of you?
Yes, sir.
Do you feel like you've had enough time to talk with her about your case and have all of your legal questions answered?
Yes, sir.
Is there anything in the paperwork that you have reviewed and had explained to you and signed that you do not understand?
No, sir.
And Mr. Thompson, I'm going to hold up a document that appears to have your signature. Is that your true and correct signature?
Yes, sir.
And did you only place your signature in these documents once you understood what you were signing?
Yes, sir.
Okay. And Ms. Beasley, do you believe Mr. Thompson to be competent today?
Most definitely, Your Honor.
All right. And you've explained to him his legal and constitutional rights.
Yes, sir.
All right. My understanding of the plea agreement, counsel, is that Mr. Thompson's going to be pleading guilty to the second-degree felony offense of assault of a family or household member by impeding breath or circulation. The recommendation from the state is 7 years confinement in the Texas Department of Criminal Justice, a $3,500 fine, $20 reimbursement fee, $290 court cost, with 142 days credit towards his sentence. Is that correct, Ms. Beasley?
Yes, Your Honor.
Mr. Thompson, is that your understanding of the agreement between you and the state?
Yes, sir.
All right. And I also see in the judgment that there is an enhancement. Is that correct?
Judge, just for clarification, it's a third degree assault, family violence. Assault, family violence, impeding. But there is a prior, which is what makes it, the second degree reflects the punishment range under the indictment, because it does have the enhancement conviction paragraph in the indictment.
Okay. Mr. Thompson, you have been charged by indictment with the third-degree felony offense of assault of a family or household member by impeding breath or circulation. A third-degree felony in the state of Texas carries a range of punishment of not less than 2 years or more than 10 years confinement and a fine not to exceed $10,000. Now, the indictment also has an enhancement paragraph wherein the state is alleging that you have had a prior commission of a felony offense, specifically in February of 2011 in this court, the 294th District Court, and the state has alleged that you were convicted of the felony offense of robbery. If that enhancement paragraph is proven or is pled to as true, then that would increase the punishment range in your case from a third degree to that of a second degree, which would be not less than 2 years or more than 20 years confinement in the Texas Department of Criminal Justice Institutional Division. Do you understand those ranges of punishment?
Yes, sir.
All right. And so, Mr. Thompson, I'm going to ask you, how do you plead to the third degree felony offense of assault of a family or household member by impeding breath or circulation?
Guilty.
And Mr. Thompson, how do you plead the enhancement paragraph wherein the state has alleged that you were convicted of the felony offense of robbery in this court in 2011? Is that paragraph true or not true?
True.
Okay, thank you, Mr. Thompson. And Mr. Thompson, have you pled guilty to this offense and true to the enhancement paragraph because you are guilty of committing the offense and because the enhancement paragraph is true and for no other reason?
Yes, sir.
And Mr. Thompson, has anyone threatened you or forced you or pressured you to enter a guilty plea or a plea of true today?
No, sir.
All right, the court will accept Mr. Thompson's plea of guilt and plea of true. Ms. Beasley, is there any objection to the admission of States 1, the stipulation of evidence?
No, Your Honor.
All right, the court will take judicial notice of Mr. Thompson's judicial confession, and States 1 is admitted into evidence. Ms. Beasley, I failed to mention to you that I do not have a court reporter with me in the court at this time. However, I am recording today's plea agreement electronically for my court reporter to produce a record, a transcript if needed. Do your client waive the formal making of a transcript for today's proceeding?
We do, Your Honor.
All right, thank you, Ms. Beasley. Is there anything else from the state?
Yes, Your Honor. I believe that there was a victim impact statement forwarded to Ms. Taberham yesterday. So we would ask you to review that at this time, and then we would have nothing further.
Thank you. I am in receipt of that, and I will review that. I'm going to take just a moment to review the stipulated evidence. All right, based on the court's review of the evidence, the court does find that there's sufficient evidence to support this plea. The court will follow the plea agreement between the state and the defendant. The court convicts Mr. Thompson of the second-degree felony offense of assault family or household member by impeding breath or circulation. Court finds the enhancement paragraph to be true. Court assesses his punishment at 7 years confinement in the Texas Department of Criminal Justice Institutional Division, assesses a $3,500 fine. Court costs the amount of $290 and a $20 reimbursement fee. Court awards Mr. Thompson 142 days towards his sentence for the time that he has spent in jail on this cause. Mr. Thompson, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. Whenever you are released from TDC, I'm going to ask that you call the Van Zandt County Courthouse or come to the courthouse and speak with the compliance officer so that you can make arrangements to have your financial obligations paid off. Failure to do that will result in this court issuing a warrant for your arrest. Do you understand, sir? All right. All right. You're free to go with the bailiff at this time. Thank you, sir.
All right, thank you.
State, I want to bring your attention to Mr. Thompson's judgment. I'm going to show you the fingerprints in here, and I've got great concern that these are not going to be legible prints. So if you're interested in this being used potentially in the future, I don't know that either one of those are going to be legible for a fingerprint expert to identify him with this. So perhaps if there's a desire, you can have your investigator have him reprinted on this judgment.
Yes, Judge, we will look into that.
I see that there's been 2 attempts, and maybe I have the copy. I don't know if there's an original out there that could be better than this. I don't know, but.
No, you have the original, Judge.
Okay. So I could just tell you that there's not a legible print on there. All right, and can we have Ms. Beasley's next client, Ms. Tippett?
It's Mr. Tippett, Your Honor, Montana.
I'm sorry,
Tippett.
I'm sorry, Mr. Tippett. All right, Mr. Tippett, if you will, raise your right hand for me, please, sir, so I can place you under oath. Mr. Tippett, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, you may put your hand down. Your name is Montana Ray Tippett, is that correct?
Yes, sir.
Are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Ms. Debbie Beasley. Are you pleased with her representation of you?
Yes, sir.
Do you feel like you've had enough time to talk with her about your case and have all of your legal questions answered?
Yes, sir.
Ms. Beasley, do you believe Mr. Tippett to be competent?
Yes, Your Honor.
And you've explained to him his legal and constitutional rights?
Yes, sir.
Have you also gone over the law regarding community supervision and violations of conditions and what may happen to him if he does not successfully complete his probation?
He is aware of all of that, Your Honor, yes.
All right. Mr. Tippett, you are charged by indictment with a state jail felony offense of possession of a controlled substance in penalty group 1, less than 1 gram. That carries a range of punishment of not less than 6 months or more than 2 years confinement in the Texas Department of Criminal Justice State Jail Division, and also carries a fine not to exceed $10,000. Do you understand that full range of punishment?
Yes, sir.
It appears to me that the plea agreement you have reached with the state would require you to plead guilty to that offense in exchange for their recommendation that your sentence be assessed at a maximum 2 years in the Texas Department of Criminal Justice State Jail Division, but that sentence be suspended and you be placed on community supervision for a period of 3 years. A $1,500 fine, the state would agree to not prosecute possession of controlled substance, penalty group 1, less than 1 gram charge that you were arrested on December 17th of 2020. You would also have $290 court costs, and you would be ordered to reimburse Van Zandt County $735 reimbursement, and you would also have to pay $180 restitution to the Texas Department of Public Safety for testing the substance in this case. Is that your understanding of the plea agreement, sir?
Yes, sir.
All right, Mr. Tippett, then how do you plead to possession of controlled substance in penalty group 1, less than 1 gram that occurred on April 26, 2020?
Guilty.
Mr. Tippett, are you pleading guilty because you are guilty of committing that offense?
Yes, sir.
Has anyone threatened you or forced you or pressured you, made you feel like you had to plead guilty?
No, sir.
Right, the court will accept Mr. Tippett's plea of guilt. Ms. Beasley, any objection to States 1?
No, Your Honor.
States 1 is admitted into evidence. The court will take judicial notice of Mr. Tippett's judicial confession. Is there anything further from the state?
No, Your Honor.
From the defense?
No, Your Honor.
And Mr. Tippett, throughout this document, I see your signature. Well, what purports to be your signature. Is that your signature?
Yes, sir.
And did you sign these documents only after you understood what you were signing?
Yes, sir.
All right, I'm gonna take a moment and review the evidence. Ms. Beasley, are there any other charges that are pending for Mr. Tippett? In this offense report, there's an allegation that he was in unlawful possession of a vehicle at the time that he was arrested on this charge. Are there any other pending charges?
There is one case that the DA has agreed to reject, Your Honor. It's a
There's no
Grand
charge.
Saline, I believe, a Grand Saline, but I think it is a possession case.
There's no unlawful use of motor vehicle or theft charge?
Not that I'm aware of.
Okay. All right, then based on the evidence before the court, I will find that there is sufficient evidence to support this plea. Court hereby convicts Mr. Tippett of possessing a controlled substance in penalty group 1 less than 1 gram. Court will assess his punishment at 2 years confinement in the Texas Department of Criminal Justice State Jail Division. Court will suspend that sentence and place Mr. Tippett on 3 years community supervision. Court assesses a $1,500 fine. Court recognizes that the state will reject a possession of controlled substance from December 17th of 2020. Court also assesses court costs in the amount of $290, orders him to pay restitution of $180, and reimbursement fees of $735. Mr. Tippett, have you ever been on community supervision before?
Yes, sir.
Did you successfully complete it or were you revoked?
I was revoked.
Is this time going to be the same or different?
It's gonna be different, sir,
Why is it going to be different?
because I got a lot of responsibilities I need to take care of out there. I need to take care of my dad and be out there for him. I need to take care of my business and be responsible and whatnot as an adult.
I agree with all those things, but do you agree with me that that's easier said than done?
Yes, sir.
I mean, it takes a real man or a real woman to be an adult and make adult decisions and be responsible and not be a drain on society. You agree with that?
Yes, sir, I do.
You know, it's a lot easier to sit in a jail cell and be told when to eat, when to go to the bathroom, when to take a shower, when to shut up, when to talk. It's easier to do that. It's a lot like being a child. Wouldn't you agree?
Yes, sir.
So I guess it's up to you now on what you're going to do. The state's giving you a great offer, considering that you've already been on probation and been revoked. You can thank Ms. Beasley for that, thank the state for that. I've approved it, so now it's up to you. If you screw it up, it's on you. You understand?
Yes, sir. Yes, sir. Mr. Martin, I got a question. I should be clear on everything. I shouldn't have any holds anywhere or anything like that to worry about.
I don't have any of that information, Mr. Tippett. That would be something that the state and your attorney probably worked through to determine if you had any other charges or holds, but I'm not aware of any, but I wouldn't necessarily be aware. I just know what's kind of put in front of me and what the state's wanting to do on their case and what you agreed to. Okay.
Judge, I believe for Mr. Tippett's information, this is all the cases that the state is aware of. In Van Zandt County, we cannot speak as to any other counties or any other jurisdictions.
Mr. Tippett, do you anticipate having charges in any other county?
No, sir, not that I'm aware of. I've had some of the jail staff, check on their computer and they haven't, had any come up. So.
Okay, well, this is what we're aware of, so we can't guarantee anything else, but as far as our business, this will resolve it here, okay?
All right.
All right, so Mr. Tippett, when you get released from the jail, I want you to be sure to report to the probation department in person no later than 10 p.m. on Tuesday. It's probably gonna, if we have bad weather tomorrow, it may be closed, and it may be closed for President's Day on Monday. So 10 a.m. on Tuesday, make sure that you have reported to the probation department And if you're not sure if they're open or not, you can give them a call. You can look up their information online, okay?
Yes, sir.
All right, you can go with the bailiff.
Judge, I believe that's all I have. May I be excused?
Have you already had all the fun that you want to have for today, Ms. Beasley?
Yes, sir.
You want to take your toy and you want to leave? Is that what you're saying?
Good night.
Fine, go back to your own sandbox then.
Thank you, Judge. I got a lot of DVDs I get to watch thanks to the DA's office.
Okay. See you, Ms. Beasley. Have a good day. Be safe out there.
Yes, sir.
While we're waiting on the next inmates, do you know who's coming up next, Deputy?
Your Honor, we do have Mr. Dahl in the room and Mr. Gutierrez.
Oh, we do? Okay, I haven't seen Mr.
Yes, sir.
Noel. So let's go ahead and bring up Mr. Dole. And while he's working his way up here, Mr. Steele, on Mr. Joshua McMartin's arraignment on his DWI third, have you had a chance to go over that indictment with him, or will you need me to pull that up when he gets up?
I don't think I've had a chance to go over with him yet, so I guess I need a second to do that.
Okay. All right. I'll pull that up at the appropriate time. All right, Mr.
Thank you.
Ashmore, are you ready on Mr. Dole?
I am, Your Honor.
All right. All right, Mr. Dole, can you do me a favor and raise your right hand so I can place you under oath, sir? Mr. Dole, do you swear that the testimony you give to this court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, you may put your hand down. Mr. Ashmore, as you're aware, I do not have a court reporter present with me in the courtroom today. She is unable to make it to the courthouse due to the inclement weather. Do you and your client waive the making of a record today? If a transcript is needed, my court reporter assures me that she can use the recording that we're making today to make such transcript. But as of right now, I do not have a live certified shorthand reporter with me today. Do you waive making a written record today?
We do, Your Honor.
All right, thank you, Mr. Ashmore. All right, Mr. Dole, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
No, sir.
All right, make sure you speak up as loud as you can for me, okay?
Yes, sir.
In this case, you're represented by your attorney, Mr. Casey Ashmore. Are you pleased with his representation of you?
Yes, sir.
Do you feel like you've had enough time to talk to him about your case and have all of your legal questions answered?
Yes, sir.
Is there anything about this plea agreement that you've read and signed that you do not understand?
No, sir.
And Mr. Dole, as your name appears throughout these documents, and I'm going to show you, as your name appears, is this your true and correct name? Your true and correct signature?
Yes, sir.
And your signature appears on several documents. You're telling me that you've only signed those documents after you've read them or had them explained to you. Is that correct?
Yes, sir.
All right, Mr. Ashmore, do you believe Mr. Dole to be competent today?
I do, Your Honor.
And you've explained to him his legal and constitutional rights?
I have, Your Honor.
The court understands the plea agreement to be that Mr. Dole is going to plead guilty to a third-degree felony offense of evading arrest or detention with a vehicle. The state's recommending 3 years confinement in TDC, a $2,000 fine, with his time to run concurrent with another case, FC 20-28. There would also be $290 court costs and a $15 reimbursement fee, with Mr. Dole receiving 81 days credit for the time that he has spent in jail on this cause. Is that your understanding, Mr. Ashmore?
Yes, Judge, but I think that the judgment needs to reflect 83 days at this point because
That is correct.
these were prepared on the 9th and we couldn't go forward because we needed to get some stuff square on our end.
All right, I will make that change and give me just one. All right, thank you, Mr. Ashmore. So it will be 80. It was 81 days on the 9th. So today being the 11th, it was actually be 82 days. Is that correct? Because the TDC day starts from today. So if it was 81 on Tuesday, well, you get, I guess you would get Tuesday and then you would get Wednesday. So yes, it would be 83.
I
Okay.
think that's right, Judge.
All right, I'll fix that and I'll fix the date.
We'll take 84, Your Honor.
Bet you will.
I tried, Austin. Lawyer math.
I'll tell you what, tomorrow I'll give that to you, okay?
Yes, sir. Now we'll go ahead and take it today. Thank you, Judge.
All right, so Mr. Dole, okay, so that was the plea agreement with regards to the evading arrest or detention with a vehicle. Mr. Dole also has FC 2028, which is a driving while intoxicated third or more, third degree felony. The plea agreement and recommendation is the same. Upon a plea of guilt, 3 years confinement in TDC, a fine of $2,100. And then the state will be dismissing a possession of controlled substance and evading arrest or detention with a vehicle and a driving while license invalid with previous convictions with 83 days credit, $60 restitution, $15 reimbursement fee, and $290 court costs. Is that your understanding on that case, Mr. Ashmore?
Yes, Judge.
All right. And Mr.
Judge, I would just note we're taking into consideration it's evading arrest with previous conviction, not with a motor vehicle.
Okay. That's
That is a state jail felony, DA 2021-0015.
All right. Thank you, Mr. Woodwhite. All right, Mr. Dole, is that your understanding of the plea agreement you've reached with the state?
Yes, sir.
All right. So, Mr. Dole, let me tell you about these two offenses. The evading arrest or detention with a vehicle, third degree felony, carries a range of punishment of not less than 2 years or more than 10 years in the prison system, TDC, and a fine not to exceed $10,000. The driving while intoxicated third or more offense is also a third degree felony with the same range of punishment, not less than 2 years or more than 10 years, and fines not to exceed $10,000 in each case. That's the full range of punishment that the court could consider, and that is, the court finds that your plea agreements do fall within that range of punishment. Do you understand?
Yes, sir.
All right. So at this time, Mr. Dole, I'm going to ask you, how do you plead to the third degree felony offense of evading arrest or detention with a vehicle?
Guilty.
How do you plead to driving while intoxicated third or more offense?
Guilty.
Mr. Dole, are you pleading guilty to each one of these charges because you are in fact guilty of each one of these charges?
Yes, sir.
Has anyone threatened you or forced you or pressured you to plead guilty to either one of these, Mr. Dole?
No, sir.
All right, the court will accept Mr. Dole's plea of guilt in each case. Mr. Ashmore, any objection to states one in each case?
No, Your Honor.
All right, states one, the stipulation of evidence is admitted and the court takes judicial notice of Mr. Dole's judicial confession. Is there anything further from the state?
No, Your Honor.
From the defense?
No.
All right, court's going to review the stipulated facts. All right, based on the evidence, the court finds that there is sufficient evidence to support these pleas. The court will follow the plea agreement in each case for Mr. Dole. Court, in the evading arrest or detention of the vehicle, hereby convicts him of that offense. Court assesses his punishment at 3 years confinement in the Texas Department of Criminal Justice. Court assesses a $2,000 fine and orders the sentence in this case to run concurrent with the sentence in FC 20-28. Court assesses a $2,000 fine, $290 court cost, $15 reimbursement fee, and awards Mr. Dole 83 days credit for the time that he has spent in jail on that cause. With regards to the driving while intoxicated, third or more, the court also finds sufficient evidence to convict him of this offense, and the court does so and assesses his punishment at 3 years confinement in TDC, assesses a $2,100 fine, $290 court cost, $60 restitution, $15 reimbursement fee. The court also dismisses under section 1245 DA 2021-17, possession controlled substance, penalty group 1, less than 1 gram, DA 2021-15, evading arrest or detention with previous conviction, and DA 2021-16, driving while license invalid with previous conviction. Mr. Dole, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of your sentence. Good luck to you, sir.
Thank you, sir.
Good luck, Mr. Dell. Sorry I'm not there in person. The weather prevented that.
Thank you, sir.
And Deputy McLeish, I'm going to need to have Mr. Dole fingerprinted on these two judgments, so we'll have to send those over there to you.
Yes, sir.
If you could do that for us, I would appreciate you so very much.
Absolutely.
And Deputy McLeish, I also emailed you a copy of the fingerprint page on Mr. Thompson. If you could help us with getting a better fingerprint for him and then also bringing that back to the courthouse.
Yes, ma'am, I certainly can.
We appreciate you.
Where's that fancy black pen? All right, there's one set of closing documents. I need to change the date on that. Back to Mr. Dole. Unless he already has a copy. All right, there's that. Does this one need to have, is this for both cases? I don't know if you need to put that other FC number up there. Yes, you are correct. Good catch on that. Give me just one moment.
No problem, Your Honor.
Thank you.
Mr. Ashmore, I'm going to invite you to a breakout room real quick. I need to have a conversation with you.
Judge, I couldn't hear you. Sorry, the dogs lost their mind.
It's okay.
Did you need me in a breakout room?
Yes, I'm gonna invite you to a breakout room real quick. Okay.
Hey, Deputy McLeish, can you hear me?
Okay, Mr. Murlater, how are you doing?
I'm doing okay. How are you doing?
Doing good, thank you.
So I had a late addition to the court's docket. It was Philip Maroney. That's a plea. If
Yes,
the
sir.
judge can get to it. Do you know if that's already on your plate?
It is, and we're actually waiting for him to step through the door any minute.
Okay. We already submitted the plea paperwork, so we don't need any fingerprints. We got that done yesterday.
All righty.
How's the
We
property?
haven't had much luck with the fingerprints today.
Yeah,
It's still keeping me busy.
I bet. It's gonna take a while.
You guys should take a seat on. It's gonna take a very long while, yes, sir. But between the condition that it's in and my learning how to do the job properly, it's gonna take a long while, so. But
I don't know.
making baby steps.
But we had talked about a couple of weapons for one of my former clients. He sent me a few descriptions of that, and I'll just forward it to you. So whenever you get a chance to look at it, take a look.
Excellent, thank you. I would appreciate that. Did you get to stay in today or not get out on the roads or?
No, I stayed in. I was just at the office all day. But I'm going to go to Wood County soon to go pick up some discovery. So.
Well, be careful. I've heard from people who were in Tyler that it wasn't so bad down there, but it was dicey up here this morning, at least Canton and north of here, so.
Yeah, today was the coldest I've ever seen it as far as temperature is concerned. It was 30 degrees in Tyler, but it didn't feel like 30. I guess it wasn't much chilly.
No, it felt like 20.
It was 20 over there?
It felt like 20. No,
Uh-oh.
it felt like it.
No, I don't know what makes it colder, but I don't know. It just didn't feel as cold today, or maybe I just have put on some natural insulation over the pandemic. Maybe that helping.
Pandemic wear.
Yeah. My dog is cold though. I have a 1.5-year-old Boston Terrier, and he was just clinging to me this morning. He was that cold. I was like, so I turned up all the heat everywhere in the house so that he's nice and warm now. He's probably tearing apart my bed right now.
Yeah. Those are cool dogs, but they don't have coats. Do you have a little jacket for him?
I didn't get a jacket. I just turned up all the heat in the house. When I go to sleep, I don't turn up the heat in the house. I like it frosty. And he sleeps in my bed with me. He's a really, he's one of those dogs that has like separation anxiety turned up,
He's a snuggle bug.
He is. He's a really good dog. But yeah,
Good.
right before I turned up all the heat in the house. So it should be nice and comfy.
You're a good daddy.
Do you have any dogs, Deputy McLeish?
Oh, yeah. We've got a dog and a horse and a mule and chickens and we got all kinds of stuff. But only the dog stays in the house. The others,
Okay. Judge, I believe you're muted.
That's my line, Mr. Merleader. That's my line, okay? Who do we have next, bailiff?
Well, we have Mr. Gutierrez. I don't know if Mr. Knowles is available, but then we also have Mr. Martin and Mr. Maroney. I'm sorry, sir.
Go ahead and bring Mr. Maroney. He's got a plea. We're ready on that. And I have not seen or heard from Mr. Knowles. So we're going to just keep on trying to contact him. But if you bring Mr. Maroney, we'll do his plea. All All right, Mr. Maroney, if you will, raise your right hand, sir. I'm going to place you under oath. Mr. Maroney, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, Mr. Maroney, you can put your hand down. All right, you are Philip Ray Maroney Jr., is that correct?
Yes, sir.
And Mr. Maroney, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Little.
Little. And have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you are represented by your attorney, Mr. Shravnesh Muralidhar. Are you pleased with his representation of you?
Yes, sir.
Do you feel like you've had enough time to talk to him about your case and have all of your legal questions answered?
Yes, sir.
Throughout the paperwork, I see what appears to be your signature on some documents. Let me ask you, does this appear to be your true and correct signature?
Yes, sir.
And did you sign these documents only after having read them, had them explained to you and understanding?
Yes, Your Honor.
And Mr. Maroney, you understand everything that you read and signed today. Do you have any other questions before we go any further?
No, sir.
All right, and Mr. Muralidhar, before we get much further, I want to tell you that I do not have a court reporter here with me in the courtroom today. However, I am recording this proceeding that can be transcribed at a later date. Do you waive the formal making of a record, a written record today?
Yes, Your Honor. We would make an oral motion to waive the making of a written record. Both me and my client would do that.
Thank you, Mr. Muralidhar. The court will grant that oral motion. And do you believe your client to be competent today?
Yes, Your Honor.
And you've explained to him his legal and constitutional rights?
That's correct, Judge.
All right, Mr. Maroney, you are charged by indictment with a third-degree felony offense of possession of a controlled substance in penalty group 1, greater than or equal to 1 gram but less than 4 grams, that carries a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice, and also carries a fine not to exceed $10,000. Do you understand that full range of punishment?
Yes, sir.
All right, make sure you speak up as loud as you can. Now, the court is going to review your plea agreement, and if your plea agreement that you reach with the state falls within that range of punishment, then the court will consider that. And right now it appears that it does, in that you're going to plead guilty to that offense in exchange for the state's recommendation to this court that your punishment be assessed at 4 years confinement in TDC, a $2,000 fine, and then restitution in the amount of $180. And it appears the state's going to dismiss 2 other charges, both drug-related charges. Is that your understanding of the plea agreement, Mr. Maroney?
Yes, sir, Your Honor.
All right, so Mr. Maroney, let me ask you at this time, how do you plead to the third-degree felony offense of possession of a controlled substance in penalty group 1, greater than or equal to 1 gram but less than 4 grams?
Guilty.
And Mr. Maroney, are you pleading guilty because in fact you are guilty of that offense and for no other reason? And Mr. Maroney, has anyone threatened you or forced you or pressured you to plead guilty to this charge?
No, sir.
All right. Court will accept Mr. Maroney's plea of guilt at this time. Mr. Muralidhar, any objection to States 1?
No, Your Honor.
All right, States 1, the stipulation of evidence is admitted, and the court takes judicial notice of Mr. Maroney's judicial confession. Is there anything further from the state?
Your Honor, just for Mr. Maroney and for Mr. Muralidhar's information, the new possession of controlled substance case was unfiled, and we have prepared the disposition on that, and we'll be sending that shortly.
Okay.
Thank you, Ms. Heisel.
Anything further from the defense, Mr. Muralidhar?
Judge, this is the first conviction for Mr. Maroney on a felony. The state had provided him an offer where he would be willing to, or would he was offered safety for probation. But because of the pandemic and the extended period of time that defendants have to wait in jail, Mr. Maroney had rejected that. And I'm running into that kind of an issue with several of my clients. They're just not willing to accept safety because of the months-long wait in the jail. But Mr. Maroney did ask for straight probation with the state, had rejected that. So that's why he's accepted the 4-year CCJ.
Thank you, Mr. Murray Leader. All right, the court's going to review the evidence briefly. All right, based on the court's review of the evidence, I find that there is enough evidence to support this plea. The court hereby follows the plea agreement that Mr. Maroney has met or reached with the state. Court hereby convicts him of that offense, assesses his punishment at 4 years confinement in the Texas Department of Criminal Justice Institutional Division, assesses a $2,000 fine, orders restitution of $180. Court also dismisses under Section 1245 of the Texas Penal Code, cause number CR 20-219, possession of controlled substance, penalty group 1, less than 1 gram. Court also dismisses, or court recognizes that the state is agreeing to reject DA 2021-29, possession of controlled substance, penalty group 1, 1 gram to 4 grams. Court assesses court costs of $290 and reimbursement fees of $35. Court also awards Mr. Maroney 74 days credit for the time that he has spent in jail on this cause. Mr. Maroney, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of your sentence. Good luck to you, sir.
Good luck, Mr. Maroney. Judge, that's all I have for today. May I be excused, Your Honor?
Yes, sir. Thank you, Mr. Murray Leader.
Thank you for taking up the plea, Judge.
Absolutely. And I have your motion to pay, and I'll get that signed today as well.
Thank you, Judge.
You're welcome. Getting on at 3:30? 3. Okay. Looking, there's a stipulation of evidence form that's out of phase. Can you put that in the right spot? Deputy McLeish, the attorney, Mr. Knoll, for Mr. Gutierrez is going to be logging on Zoom about 3:15 after we conduct our Zoom on Miss Ozuna in Henderson County. So if he's there in the courtroom, you can inform him of that.
He heard you, Your Honor. Thank you, sir.
Okay, you're welcome. All right, is Mr. Steele's client available?
Mr. Martin, yes, sir.
Hey, Judge.
All right, this is cause number CR 19-180 and CR 2398. Let me pull up that new indictment for you, Mr. Steele. that's not the right one. Hmm. Bear with me just a moment. All right, now I think we're getting somewhere. All right, this is cause numbers CR 19-180 and also CR 2398, State versus Joshua Mac Martin. We're set for hearing on the motion to revoke in the CR 19 case and an arraignment in the CR 20 case. Let's begin with the arraignment in CR 2398. Mr. Martin, can you see the indictment that the court's displayed on the screen?
Yes, sir.
Okay, go ahead, Mr. Steele.
Mr. Martin, can you hear me?
Yes, sir.
Okay. Do you see where your names appears on there on the indictment?
Yes, sir.
Exactly. Is your name spelled correctly?
Yes, sir, it is.
Okay. And you understand that the charges against you are DWI third or more, which means that the state is alleging that this is your third or more DWI. You understand that's the charge against you. I'm not asking you whether or not that's true. I'm just asking you understand that's the charge against you.
Yes, sir, I do.
Okay. That's sufficient for my purposes, Judge.
Okay. All right. And how does Mr. Martin wish to enter his plea?
Yeah, we'll waive any further arraignment, enter plea of not guilty, Your Honor.
Okay, court will enter Mr. Martin's plea of not guilty into the record for the driving while intoxicated third or more offense alleged to have occurred on July 26th of 2020. All right, before we set the pretrial hearing in that case, what's the announcement on the motion to revoke case?
Judge, I've been in contact with the state. We've had multiple conversations. They've made me an offer. I think I need to talk to the client. I think maybe we might be able to get this worked out. So I was hoping maybe to reset the pending MTR with the pretrial hearing, if that's acceptable to the court.
Okay. Are you available on March 23rd or 25th? And we can even set it sooner if you feel like you may be able to reach a resolution. We could do it as early as March 11th.
Yeah, I'll take the 23rd and the 25th. What days of the week is that, Judge?
Tuesday and Thursday.
I will take. I'll take the 23rd.
Okay.
And if he's still in jail, it'll be the afternoon of the 23rd.
That's correct.
Okay. I did have one question.
Yes, sir.
The state and I might be able to work this out. If we do, then it won't be necessary for me to ask for a bond on the probation violation. But if the state and I are not able to work it out, do I need to file a formal motion? I don't think we have agreement on bond. So I need to file a formal motion and ask the court for a bond?
Yes, sir. You'll need to do that. And if you want the court to conduct a hearing, you'll need to do that well in advance of either this date so we can take it up and the state has notice, or if you want the bond quicker than that, you'll need to file that motion, give the state notice, and then request the coordinator to set it.
Okay. I think I'll have an answer on that next week, Judge.
Okay. All right. So the court's setting the motion to revoke hearing for March 23rd at 1:30 and the pretrial hearing on the subsequent driving while intoxicated third or more on the same date at 1:30 if Mr. Martin is in jail, 9 a.m. if he is on bail.
Judge.
All right. Thank you, Mr. Martin. Thank you, Mr. Steele. Is that all you have?
That's all I have today, Judge.
Thank you, sir. Good to see you.
All right. Good to see you. Bye-bye.
All All right, Mr. Noel will log in at 3:15. Just for the record, Frankie Rodriguez, we're not bringing her up. She's been reset until next week, 2:18. That's Mr. Ashmore's client. Mr. Devine also reset to 2:18 for plea. So that leaves us Miss Ozuna and Mr. Adams at 3 o'clock. She'll zoom in from Henderson County. And Mr.
Judge, what about Miss Brianna Musgrove?
Yes,
Also, Mr.
she's
Casey?
also been reset till 2:18 at 1:30.
Thank you, Your Honor.
Yeah, she was the Louisiana lady.
That's correct. That's correct. I forgot about that. Yes, sir.
So we'll wait, just those two. So we'll just stand in recess for a few minutes. They should be logging on any minute. So I'll bring them in as soon as I see them.
Thank you, Judge.
Thank you, sir. Mr. Adams, we do not have Anderson County logged in yet on Miss Ozuna, so we're contacting them, try to find out what the deal is. I'm gonna go ahead and talk with Mr. Knoll about Mr. Gutierrez, and then that'll just, should be able to finish him up quickly. And then
Okay,
hopefully Ozuna will be logged in soon.
all right, that's fine. No rush.
Mr. Gutierrez, are you there in the courtroom? If you are, will you step up to the podium?
Afternoon, Judge.
Good afternoon, Mr. Knoll. How are you, sir?
Pretty good.
This is cause number CR 25, State versus Jesus Humberto Gutierrez. And we are set for a docket call today on his aggravated assault deadly weapon charge. Go ahead, Mr. Knoll.
Judge, one, I apologize for not being on the Zoom. I actually came over this morning. We had a plea agreement. Thought I was going to pick up plea papers. DA's office was closed. Courthouse was closed. I have relayed the offer to Mr. Gutierrez. He is willing to accept that. The offer that I received from the state was 8 deferred, $2,500 fine, attorney's fees, and court costs. But I do not have plea papers, or could not pick up plea papers today, but we would be prepared to do that plea sooner than later, as soon as we can get that set, I guess, Judge.
Did you say there was any jail time as a condition?
No, Your Honor, he's been in jail a while now, but there is no jail time as a condition, no.
So 8 deferred, and he was going to take that today. State, do you want the court to grant any type of PR bond or anything to get Mr. Gutierrez out today, and then we can set him for court next week to have him do that?
Judge, I guess that would probably obviously benefit him and be one less mouth to feed, so to speak, in the county jail. So I would be happy to do that. I do have some settings here, Zoom settings all in Tyler next week, but if I could check that. If I could, Judge, my laptop is actually sitting on my hard calendar. I'm going to
Sure,
move it.
yeah, sure.
Second.
Yeah, you could, we could do him either on the 9th or the 11th. State, what's your position on that?
Judge, state has no objection. We have extended the offer that Mr. Knoll relayed to the court. We did anticipate he'd take that today. I have no reason to continue to hold him pending the resolution of this cause.
And Judge, the court said the 9th or the 11th. I was talking about, I guess, then March.
I'm sorry, I'm on the wrong day. Sorry, hang on.
Or next week, I guess is what
Yeah,
I.
today is the
Next week.
11th.
Next week, 18th. Could you? So that's a week from today.
Judge, on the 18th, the only thing I have 3 pleas at 10 o'clock on the 18th. I could be there in the afternoon or get it done at 9 and be back, I guess. Well, no, I'd have to do it in the afternoon on the 18th.
Yeah, that's gonna be difficult because we've got the jail. Because we're talking about getting him out of jail today.
That'd be preferable, yes, Your Honor.
I'm in deep thought, hang on.
Okay.
Let me look at my calendar real quick.
Judge, I have my completely open day for my end is the 17th. And then the 18th, I have that plea. And then on the 19th, I've got afternoon plea. Or actually, their sentencing's on the 19th.
I'll tell you what, let's just set it on the 18th in the afternoon.
Okay, would that be 1:30, Your Honor? Or?
1:30, and Mr. Gutierrez can report to the courthouse, and he can do the plea via the the video conference room that I have here in the courthouse. You can meet him here if you need to. I don't want him going to the jail. I've got to make sure that we're not putting people out to the jail who are not in jail.
Okay, I understand.
Don't want to overrun the jail courtroom. So he can just appear here at the courthouse. And if you're at the jail, he could, if you've got clients at the jail that afternoon, I don't know if you do, but if you do, you can appear out there. He can appear here via Zoom. You would just have to connect with him to get the paperwork done at some point.
Okay. So make sure he understands that. Mr. Gutierrez, you understand, if I understood what's happening, the court's going to release you today, I guess on a PR bond, and you would need to be back in court at the courthouse. I will meet you there 12:30 on the 18th so that we can make sure we've got all documents ready to rock and roll for a 1:30 setting. Would that be a correct recitation, Your Honor?
I believe so, Mr. Knoll. And Mr. Gutierrez, just raise your hand if you understand, because I don't know if there's anybody in there to unmute the device for you. Okay, so you're raising your hand that you understand. So the court will send over an order to release you today, and then you're to appear in the courthouse at 1:30 on Thursday, February 18th, 1 week from today. And Mr. Knoll will meet with you and go over the paperwork, and we'll get you finalized, and you'll go on probation that day.
And make sure that you need to be there for a meeting with me at 12:30, and I guess raise your hand if you understand that. Okay, we're good.
Okay, all right. As soon as I'm finished today, Mr. Gutierrez, I'll get that order sent over. All right, you can go ahead and have a seat.
Judge, I think that's all I have on this afternoon's docket.
Yes, sir. I think that completes you. I guess we'll see you next week.
Okay, thank you, Judge.
You're welcome. Have a good day, man. Be careful.
You too. Bye-bye.
All right, Mr. Adams. Ms. Tabor has been texting the Henderson County Jail, and they indicated that one of their judges needed to use the Zoom room. It sound very good, the Zoom room. Anyway, so they asked if we wanted to try again at 4 p.m. I'm not necessarily inclined to do that. What kind of announcement were you going to have on Ms. Ozuna?
Very simple, Judge. I'd have to ask for a reset. I had a plea offer from Mr. Woodwick as of last week. He and I did some horse trading. I got a new plea offer from him yesterday, but have not had the opportunity to discuss it with Ms. Ozuna yet. She's in the Henderson County Jail, as we know. And I found that out on Monday, I think it was, and the week has just not allowed me to get over to Athens yet to visit with her. So if it's, I think we'd end up having to punt anyway to give me the opportunity to go visit with Miss Ozuna and find out from her what she wants to do.
Okay.
And it's an offer for time, so I can't say with any degree of confidence that she's going to be I cannot speak for her right now as to whether or not she'll want to accept it.
Okay. Let me look at something real quick. All right, this is what I propose, Mr. Adams. I propose that I set this for a contested evidentiary hearing on 2/25, and that gives you time to talk to Miss Ozuna about the offer and for y'all to finalize any of your negotiations. And then if she decides she doesn't want to accept it, then we'll just go forward with a hearing on her case on that Thursday, 2/25. If she wants to accept, then we can enter the plea that day.
Understood, John.
Will that work for you?
Yes, that's fine. Would that be, I guess that would be an afternoon hearing?
No, actually, we would probably start that in the morning on evidence
Okay.
days. We start everything at 9 a.m. so that we can work through our hearings. But so that's only 2 weeks.
That'll be plenty of time, Your Honor.
Okay. So we're not going to bring her in for this hearing. We'll waive her appearance and just reset her for that contested evidentiary date. And we'll see you back on 2/25 at 9 on her case.
That works.
Thank you, sir. Appreciate you.
Thank y'all. Take it
All
easy. Be careful out there. Good to see everybody.
Yes, sir. You as well. I believe that concludes our docket for the afternoon. Do you see that I've missed anything?
No, Judge, that appears to be everything.
Hey, I want to just say thanks for sticking with me today and working through. Ms. Abraham tallied up that we resolved 9 cases today. When courthouse was closed, we managed to find a way to get it done. So I'm thankful for the jail and for the defense bar for sticking through, and you two also for getting up, and you could have easily just phoned it in, and I appreciate you not doing that. And we got people out of jail. We got people moved on to TDC. So I feel like it was a very productive day. So just want to commend y'all for doing that and say thank you very much.
Absolutely.